The coins alert is the source of all of the information that is described in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Take a look at this now, shall we? If UC loses their appeal, how much money will it be required to pay Ripple as a result of? A post that was published on X, a lawyer by the name of Fred Rispoli has once again started conversations regarding the prospect of launching an appeal in the XRP litigation. There has been a lot of talk about the potential financial implications that could befall the United States Securities and Exchange Commission in the event that it is unsuccessful in its appeal. The question of whether or not the check from the Securities and Exchange Commission would just be used to refund Ripple $125 million in penalty or additional statutory interest payment has been brought up at a recent conversation that was triggered by a lawyer called Fred Rispoli, who is an advocate for XRP, assuming that the United States Securities and Exchange Commission is unsuccessful in its appeal of the $100 million XRP lawsuit that is now being litigated in the cryptocurrency market. The lawsuits that have been filed in relation to XRP have been one of the most notable phenomena. Ripple was recently sentenced by Judge Elisa Torres to pay a civil penalty that was in the amount of $125 million. After discovering that the company's 1,278 institutional selling transactions were in violation of securities legislation, the judge came to this conclusion and made this announcement. A significant number of individuals operating within the cryptocurrency industry, on the other hand, consider this to be a partial victory for the blockchain corporation. In particular, especially in light of the ruling that was reached the year before that XRP is not a security. At this point, the focus of the conversation has switched to the possibility of an appeal being filed by the United States Securities and Exchange Commission, in addition to a cross-appeal being filed by the blockchain payment enterprise. However, in the meanwhile, the idea of submitting an appeal has recently gained momentum once more, particularly after a lawyer named Fred Rispoli, who is an advocate for XRP, brought out an important question. He learned that the Securities and Exchange Commission Secretary would be obliged to not only repay the $125 million, but also pay statutory interest if Ripple is successful in an appeal on all concerns. This information was obtained by him. A comment was made by James Farrell, a former attorney for the Securities and Exchange Commission, in which he noted that the SEC might be responsible for paying any costs associated with the appeal if the company is successful in its appeal. Additionally, in addition to that, the agency in question can be compelled to pay additional fees, such as the payment of the bond, in accordance with certain legislative regulations. Furthermore, Farrell brought to light the prospect that the case could be remanded for a new trial, which would result in additional legal battles. This would be a result of the case being remanded. An additional layer of complexity would be added to the situation as a result of this. It is important to note that the unpredictable nature of the issue, as well as the potential financial stakes that are involved, is brought to light by the fact that the blockchain corporation may choose to cross-appeal and oppose the ruling that the court made regarding institutional sales and on-demand liquidity of transactions. A potential appeal and the implications that Ripple and the SEC would face as a result of using it. The prospect that the Securities and Exchange Commission (SEC) will file an appeal has been the subject of speculation for a number of months. According to legal experts such as Meta Wayman, it is anticipated that the United States Securities and Exchange Commission will file an appeal against the order, with a particular emphasis on the conclusion that the court made regarding disgorgement. In addition to this, he added that Ripple may file a cross-appeal, arguing that the decision that the court made regarding institutional sales was flawed. In accordance with the Howey test, the blockchain payment business has the ability to argue that these transactions do not fulfill the requirements of an investment contract. In the event that this argument is successful, the position of the CC may be further undermined, and it may also have far-reaching ramifications for other disputes involving cryptocurrencies, such as those involving Binance, Coinbase, and other companies. In addition to that, it has also sparked conversations about a resurgence of a conflict in the XRPs which had just recently resolved. Previously, during the time that this article was being written, the price of XRP had grown by around 2 cents, reaching 59 cents. However, the volume of its trade remained relatively stable at $1.08 billion. A recent forecast for the price of XRP suggests that the cryptocurrency might reach 74 cents in the near future, assuming that certain conditions are met. This is an important prediction with implications. It is possible that the Securities and Exchange Commission will not file an appeal against the decision that was made in the XRP dispute that is now under consideration. Torres would be judged for launching the case against XRP in the first place, according to a lawyer called Bill. Morgan, who brought attention to the fact that judges in the litigation against Binance and Kraken side with Judge Torres. On X, members of the Bitcoin community voiced their opinion that the SEC is crooked. According to Bill Morgan, an attorney who specializes in digital assets, the United States Securities and Exchange Commission may decide not to appeal the verdict in the Ripple case if the decision is being influenced solely by legal reasons. Morgan made this statement to the media. It has been announced that Judge Orek, who was assigned to the Kraken case, has joined forces with Judge Jackson, who was assigned to the Binance case, and Judge Torres, who was assigned to the XRP lawsuit. In a post that Morgan made on social media site X, which was then known as Twitter, he brought attention to the fact that Judge Torres, Judge Jackson, and Judge Orek all made a distinction between transactions that took place on the primary market and those that took place on the secondary market. A stir ensued within the community as a consequence of the fact that Judge Rakoff in the Terraform Labs case did not make any distinction with regard to this matter. Rakoff's decision was criticized by a number of commentators for being inconsistent, which indicated that Judge Torres' reasoning in the XRP dispute was not very reasonable. This is due to the fact that the SEC's likely appeal of Ripple's historic victory is currently in the balance. Following Ripple Labs' victory over the Securities and Exchange Commission, there has been a tremendous amount of noise in the weeks that have followed. It is possible, according to Mr. Huber, a cryptocurrency expert, that the SEC will postpone an appeal until the rate decrease that takes place in September. Regarding Bill Morgan, he is not completely confident, but he estimates that there is only a 60% chance that the Securities and Exchange Commission will not appeal. As a consequence of these potentially contradicting signals, the Bitcoin market is gearing ready for what may be yet another intense legal confrontation. It is a very intriguing case to consider. On the question of the ruling being advantageous for the SEC, I relate to some of the emotions that you have expressed. There is a great deal of comprehension in the explanation that the judge provided. As a lawyer, you are the kind of person who takes pleasure in reading decisions such as this one, which have been published in the CV since the final ruling. On the 7th of August, Judge Analisa Torres issued her decision regarding the Ripple case. Concerning the question of whether or not it will file an appeal against the ruling, the CC has not made any public pronouncements. In his commentary on the topic, legal expert Bill Morgan has indicated that the Securities and Exchange Commission may not appeal if it is only influenced by legal concerns. Morgan's comments were made in response to the matter. It was brought to his attention that recent judicial trends, such as Judge Orek's preference in the Kraken case for distinguishing between primary and secondary market transactions, which is comparable to the preference of Judges Jackson and Torres, could potentially impact the judgment that the SEC makes. This was brought to his attention. Morgan's words contain a growing amount of uncertainty over the next action that the Securities and Exchange Commission SEC will take. Is it true that the case concerning the CN Ripple has been resolved? In a series of blogs that he has written about the ex-pro XRP attorney bill, Morgan has voiced an increasing level of doubt regarding the likelihood that the United States Securities and Exchange Commission will appeal the recent announcement of the Ripple summary finding. In the event that the decision is entirely based on legal reasons, Morgan creates the impression that an appeal might not be sufficient. He emphasizes the most recent judicial trends that have the ability to impact the judgment that the CC makes, particularly the compelling explanation from judges who have ruled in cases that are comparable to the one it is currently considering. Will Ripple be successful once more, or will the SEC resort to filing an appeal? Investigate the odds for both of them. Judge Orek is responsible for implementing the rulings that Ripple and Binance have made. There have been a number of detractors, including who have voiced their disagreement with the decision that Judge Torres made over the Ripple summary judgment. The fact that the judges in the Orek-Decker case and the Jackson-Binance case have expressed good comments about certain aspects of Judge Torres' reasoning, on the other hand, ought to help to assuage these concerns. In his most recent